My name is Jason Montgomery. I'm a partner at Husch Blackwell. My colleague Elizabeth Samples is also a partner. We work in the higher education group and really work with institutions like yours, higher education institutions, colleges and universities in all areas of legal and regulatory issues that affect them. Title IX, college athletics issues, financial aid issues, really everything. And we do quite a bit of work with NAIA schools here locally in particular. Today what we want to talk about, and I'm going to turn it over to my esteemed colleague to do a majority of the talking today about Title IX in particular, but we want to talk about a little bit about current issues in college athletics, the NCAA versus Alston case, and that's not a typo. I know we're at the NAIA, but I can talk smack on the NCAA when I'm talking the NAIA, so it's a positive thing. So we're going to talk a little bit about that. We're talking about the big topic that everyone is talking about, which is name, image, and likeness, how that's affecting your campus, some of the regulatory compliance issues you all need to be aware of as you're navigating that space. Touch a little bit on the college athlete rights movement, which I think is important to understand, and we talked a little bit about the well-being of athletes, and that's going to continue to be a theme, I think, moving forward for institutions to be aware of how their athletes are being treated, if there is any concerns related to how coaches and their styles are working with their athletes, and how that can affect a campus culture and can result in some liability. And then finally, I'm going to turn it over to Elizabeth to talk about Title IX, and that's going to be a big focus of this presentation, both athletics considerations and sexual harassment, misconduct, which I think is what people now associate Title IX primarily with. So without further ado, let's jump right in. So NCAA versus Alston, this was a Supreme Court case, and the reason I'm talking about it is because this is one of the biggest cases to come out of the Supreme Court in college athletics in about 4 decades. So 40 years or so they went without a case. Essentially in this case, the NCAA basically said to the court that we're special, we deserve special treatment because we're involved with college athletics. And when they said special treatment, they were talking about special treatment related to compensation and rules regulating compensation to athletes. And what we're talking really about here is amateurism rules. Ultimately, the Supreme Court said, no, you're not special. You all are governed by the same laws as any other organization. And here, you violated antitrust law by limiting the amount of compensation athletes can receive. And in this case, it was about what they called education-related benefits. So things associated with the athletics participation that were not athletics-related, but were related to their enrollment as a student. Think about computers provided to athletes, think about musical instruments, paid internships. That's what that case was all about. And at one point, there was some pretty strong language from the Supreme Court that said, hey, NCAA and other like associations, NAIA could be a like association, it's important that you manage this space, intercollegiate athletics, in a certain way, and your rules are consistent with managing that way. And if your rules are consistent with managing the sport programs that way, then they're consistent with antitrust laws. And there was some dicta, which means other language, in a Supreme Court case that basically said that. So for 30 plus years, the NCAA relied on this language that said, we think your rules aren't going to violate federal law. So your rules are going to be, whatever rules the NCAA put in place, they relied on this rule. And this case basically overturned that and said, we're no longer relying on that. We're going to evaluate all of your rules to determine if there's a legitimate purpose, like we would in any other antitrust situation. Make sense? And Justice Kavanaugh, and it says judge here, it says should justice, don't tell anyone at the firm. Justice Kavanaugh, in his concurring opinion, suggested that many of the other NCAA rules could also violate antitrust provisions. But what they were talking about here really is the upper echelon of college athletics, right? Division I, Power 5 schools and their conferences making millions and billions of dollars. However, how does that affect everyone? Well, once this case came out, this was a key reason why the NCAA deregulated name, image, and likeness rules for all divisions. And it has resulted in the NCAA completely determining that they may reimagine how they're going to govern themselves. And I think it's fair to say that if the NCAA is reimagining how they're governing themselves, that ultimately could reflect what the NAIA does. Now, to be frank, the NAIA was way in front of everything that the NCAA was not, including name, image, and likeness. And had early on adopted a rule that we'll talk about here in a minute that deregulated that area. But I think the key thing to think about here is we used to live in this world in college athletics, and believe it or not, I was a former college athlete, an NAIA athlete, so the NAIA is really a place in my heart here. But we're going to start thinking about a college athlete model and not a amateurism model. For years and years, we always thought of everything as being, this is all amateur, and we're slowly shifting to something a little bit different, even at the NAIA level. And this is most apparently reflected for you all in the name, image, and likeness rules. I think what is important to take away from here is that really for you all, depending on what state you're in, this is really a state-by-state analysis you need to go through in order to determine whether what you're doing on campus is consistent with not only NAIA policy or NAIA rules, but the state law. There's about 28 or so state laws that are currently in effect. For example, Missouri has an NIL law. Kansas doesn't. So you just go over to the Kansas side and completely different set of parameters. From the NAIA's perspective, they deregulated, as I said, this way before the Alston case came out. They saw the California decision that they were going to implement a name, image, and likeness law, and decided based upon that we're going to deregulate this at the NAIA, with the only caveat that it's the responsibility of the student athlete to notify the institution's AD about if they receive compensation based on the use of their likeness in relation to their school or status as a student athlete. So what does that mean? I think it means to you all that when you're looking at NIL and your students making money, that if they're using your institution's logo or their status as a student athlete, they're supposed to, under NAIA rules, report that to your school. Now, separate from that, many state laws have reporting requirements. They have requirements related to what you can do with intellectual property, so how you can use your logos of your schools to earn money for yourself as an athlete. They, some of them have education requirements, and some of them have prohibitions on booster involvement. Now, there's nothing in here about boosters or anything like that. I think it's fair to say that either under the NAIA rule or any other association that boosters, however you want to characterize them, could engage in these activities with your athletes. I think what is probably most important is that these aren't used as a recruiting tool by institutions. I think this was really designed, and the way it's been portrayed, as a separate ability for athletes to do what any other student could do, which is get on TikTok and make a dance video, right? Everyone has the freedom of speech to do that. So that's what this is supposed to be about. So what are your considerations? And if you have institutional policies and procedures, I do think there's a few things you all need to look at and then evaluate how your school is handling it. First is value-based prohibitions. That's another component that is in many state laws. A prohibition on athletes promoting alcohol, products related to alcohol, prohibition on athletes promoting gambling, some prohibition on guns and related activities. So there are some specific prohibitions in state laws that you need to be aware of. Also, you have to look at your institution's philosophy, right? Many, including my alma mater, small Christian-based schools have a certain philosophy where you may want to ensure that your athletes or your brand is not going out and promoting something that's inconsistent with your values. And it's perfectly within your rights to set to set a limit for your athletes as to how they can use your logos and their status as a student athlete at your school, like you would with any other student. With respect to a release, use of likeness for institutional purpose, it's always a good idea for you to have a general release of likenesses for your athletes. And many of you probably already have that, just like you would if you were putting a student on the cover of a catalog back in my day when you had catalogs. But when you put people in any sort of media context, it's important to have a release. And so now, more so than ever, with athletes, now that they can earn compensation themselves, it's important that you have a release for anything that you're using your athletes to promote, any sort of endeavor, including athletics contests. The other issue that has come up in we're 8 months into really this being something that's consistently happening in schools, are team rules and policies surrounding social media. So as you guys are aware, there's been a kind of long-standing tradition or opportunity for coaches to set their own team policy, their own team rules. And that's fine, that can still happen. Those rules can't infringe on the rights of individual student athletes, and in particular with name, image, and likeness, any sort of social media policy that would prohibit them from communicating or potentially monetizing that social media could subject the institution or your coaches to potential liability in that area. I talked a little bit about recruiting and booster prohibition. Employment status, I think it's important as athletes continue down this road that it's clear that at your institution they're not employees. They are student athletes. They are participating as an avocation, not a vocation, and I think it's important to include that in a policy. Many schools do that. The last piece, this is touching international athletes. So you have this whole group of students can earn money now. They can go out and get a deal with the local Pizza Hut. But international student athletes have separate requirements under their visa status that prohibits them from earning compensation outside of the some very limited opportunities within the structure of the institution. So what we've advised our clients is that at this point in time, you should ensure that your international student athletes understand that they can't do the same things that domestic athletes can do because of their visa status. And make sure that's very clear, because it could jeopardize not only their own visa status, but also the opportunity for your institution to continue to provide I-20s to other students, depending on what would occur. Some other kind of key issues as Oh yeah, please.
Question for you. As far as like your J1 and F1s that are in that scenario, what's been the most recent update as far as name, image, likeness versus visa status?
So there's been one highly publicized scenario with a Kentucky student athlete that says we got around the rule. And I just, talking with our immigration folks, knowing what I know, I don't think there's been any change substantively to the rule itself. I don't know what Kentucky's doing, God bless them. We're Jayhawks here, so you can kind of draw your own conclusions. But I will say that we are tracking that with our immigration folks, and if there is a change, we get it out to individuals that are in our community and put that out. It is the same status that currently international athletes would jeopardize their visa if they earned while they're in the country. Now, the one caveat to that, which we still think is a little dangerous to advise your athletes, is that this was all about maintaining eligibility, right? So it affected athletes when they were both in their home country and in the U.S. Now, this piece is about their status in the country. And so theoretically, if they were in their home country and received a deal, they could earn compensation in their home country for their name, image, and likeness, or before they enroll at your school. The challenge with that is, especially with social media, that it's going to be difficult to determine that this was solely based on their engagement in their home country, if it's a social media type engagement, or if it's associated with their athletics ability and that some way ties to your school. That's the challenge. And so we've continued to advise that even in those cases, we think institutions would be taking a risk if they advise their athletes in that way.
Quick question, I just don't know, but if it's on the student to report it to the institution or to their athletic department, what if they don't? Whose fault is that? Or
That's a really good question. This kind of goes into why this is where we're at with NIL. No one really knows what's going on because there's no strong enforcement mechanism. So it would be on your institution just like it would be related to a student conduct issue, related to an institutional policy right now. There's no third party that is going out and enforcing that particular rule. And the states that do have laws don't typically have, or none of them that I've seen, have enforcement mechanisms associated with that. That said, you don't want to be in a situation where you're violating state law by not complying with the policy. But that's a good point. It really comes down to how your institution at this point chooses to handle each of those issues. Some schools have said, and the state laws would back them up, that you need to report this 10 days before you enter into a contract to try to prevent the athletes from entering into a contract that might be contrary to their best interests or violative of intellectual property rights of the school. That's what I've seen institutions do. But it's a good point. It's a case-by-case, school-by-school basis. So, in addition to the international athlete issue, there are questions related to taxable income, possibly deals if they're large enough affecting federal aid. First Amendment, if you're a public institution, that could come into play in the ability for athletes to communicate, similar to what I talked about with team rules and social media, and whether there are limits on that you can reasonably place or not. And then leading into the discussion about Title IX, anytime the institution is involved in any way. So if the institution got involved in creating a network or facilitating these types of NIL agreements, then potentially Title IX at that point would be implicated. And you would have to do an evaluation to ensure that you're providing whatever benefit you're providing to the athlete in an equitable way to both men and women on your campus. Okay, with that, I'm going to turn it over to Elizabeth to talk about Title IX 101. And I gave you plenty of time.
Yeah,
right?
well,